Hello and welcome to McKenzie Friend. Today we're going to look at the child's best interests, parental responsibility and contact, and how all these elements operate under the Family Law Act. But first, the usual disclaimer. Whilst I hold a law degree majoring in family law, I choose not to practice nor sort of mission, so any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Let's look at, firstly, at the child's best interests. What it is, what are the considerations, and why it is important. Importantly, under Section 60CA of the Family Law Act, the child's best interests are paramount consideration in making a parenting order. In deciding whether to make a particular parenting order in relation to a child, a court must regard the best interests of the child as the paramount consideration. Everything else is secondary. There are objects and principles under Part 7 of the Family Law Act, where Section 60B(1) considers the best interests of children are met by ensuring that children have the benefit of both of their parents having a meaningful involvement in their lives, to the maximum extent consistent with the best interests of the child. Protecting the children from physical or psychological harm, from being subjected to or exposed to abuse, neglect, or family violence, and ensuring that children receive adequate and proper parenting to help them achieve their full potential, and ensuring that parents fulfill their duties and meet their responsibilities concerning the care, welfare, and development of their children. As you can see, these principles only apply when it's not contrary to the child's best interests. Where we'll see in Section 60B(2), children have the right to know and be cared for by both parents, regardless of whether their parents are married, separated, have never married, or have never lived together. And children have the right to spend time on a regular basis with and communicate on a regular basis with both parents and other people significant to their care, welfare, and development, such as grandparents or other relatives. And parents jointly share duties and responsibility concerning the care, welfare, and development of their children. And parents should agree about future parenting of their children, and children have the right to enjoy their culture, including the right to enjoy that culture with other people who share that culture. Now, the most important consideration with regards to child's best interest is found in 60cc(2), where A is the benefit of a child of having a meaningful relationship with both the parents and the need to protect the child from physical or psychological harm from being subjected to or exposed to abuse, neglect, or family violence. Importantly is Section 2A. In applying these considerations set out in subsection 2, the court is to give greater weight to the considerations set out in 2B, which means the need to protect the child will prevail over the benefit of the child having a meaningful relationship with both parents. There are also additional considerations. These are secondary considerations, but also are important. Often when a decision is made, these considerations are usually considered by the judge. Firstly, any views expressed by the child and any factors such as the child's maturity or level of understanding that the court thinks are relevant to the weight that should be given to the child's view. This very much depends on the maturity of the child. Often young children will not be able to express a view, so this consideration will not be considered or given significant weight. The court will also look at the nature of the relationship of the child with each of the parents and other persons, which includes grandparents or other relatives of the child. Also, the extent to which each child's parents has taken or failed to take the opportunity to participate in making decisions about major long-term issues in relation to the child, spending time with the child, and communicating with the child. Also, the extent to which each of the child's parents have fulfilled or failed to fulfill the parents' obligations to maintain a child. Now, that also means making sure that you've paid your child support. Also in D, the likely effect of changes in the child's circumstances, including the likely effect on the child of any separation from either of his or her parents or another child or another person, including grandparents or other relatives of the child with whom he's been living. So the court sometimes does not want to disrupt or disturb the existing situation. Also, the practical difficulty and expense of a child spending time and communicating with a parent, and whether that difficult expense will substantially affect the child's right to maintain personal relationships and direct contact with both parents on a regular basis. This often happens if a parent relocates, either unilaterally or with the approval of the court. Also, F, which means the capacity. The capacity of each child's parents and any other person, including grandparent or relative, the child, to provide the needs of the child, including emotional and intellectual needs. This capacity also can relate to ability to financially provide support, and also if one of the parents has, say, substance abuse, alcoholism, mental issues. Also, the maturity, sex, lifestyle, and background, including lifestyle, culture, and traditions of the child and either of the parents, and other characteristics of the child that the court thinks are relevant. In H, this pertains when the child is Aboriginal or Torres Strait Islander, and there's an importance under the Family Law Act the child can continue to maintain their culture. And I, the attitude to the child and the responsibilities of parenthood demonstrated by each of the parents. Now, the court's very sensitive to whether or not the parents are before the court because they want to fight or because they genuinely believe they're acting in the best interest of the child. So it's very important that when you're before the court, to convey to the court that your intentions in being before the court are for the best interest of the child. J, any family violence involving the child or a member of the child's family. Family violence is incredibly important in family law proceedings. You'll see again in K, if there's a family violence order has applied or applies, or the child, a member of the child's family, any relevant inferences that can be drawn from that order, taking into account the following: the nature of the order, the circumstances in which the order is made, any evidence admitted in proceedings for the order, any findings made by the court or proceedings for the order, any other relevant matter. So protection orders do become important considerations in family law matters. Finally, L, would it not be preferable to make an order that would least likely to the institution or further proceedings in relation to the child? This is about trying to ensure that proceedings will be finalised and that parties will not continue to relitigate. And the last one, M, which is basically a catch-all, any other fact or circumstance that the court thinks is relevant. Now, that was a very brief description of 60cc 3. Now, this is probably subject of a much longer and more detailed video, but we'll leave that for another day. Now we're going to turn to parental responsibility. What it is, what does it encompass, and why is it important? Firstly, what is it? Family law in Australia defines the responsibility that parents have in relation to bringing up their children. These include to protect your child from harm, to provide your child with necessaries. That means food, education, somewhere to live, to financially support your child, to provide safety, supervision and control, to provide medical care and provide an education. Now, the meaning of parental responsibility is found under 61B of the Family Law Act. In this part, parental responsibility in relation to a child means all duties, powers and responsibilities and authority which by law parents have in relation to children. Under 61C, each parent has parental responsibility subject to court orders. Now, this is important. This means even if the court has not made orders, parents at common law and under the Act of 61C have parental responsibility unless the court orders otherwise. Now, it is not affected if parents become separated or by either of them marrying or remarrying. Now we'll go on to 61D, parenting orders and parental responsibility. And this is important, how parental responsibility affects parenting orders. A parenting order confers parental responsibility for a child on a person, but only to the extent which the order confers on that person duties, powers, responsibilities, authorities in relation to a child. A parenting order in relation to a child does not take away or diminish any aspect of parental responsibility of a person for the child except to the extent expressly provided for in that order or necessary to give effect to that order. That means if it's not detailed in any parenting orders, then it doesn't apply. Now, parental responsibility, what does it encompass? There's two types of parental responsibility. Firstly, there's long-term decisions and there's day-to-day parenting. When we generally talk about parental responsibility in family law, we usually talk about long-term decisions. Now, we can find what a long-term decision is under Section 4, under the definitions under the Family Law Act, which details parental responsibility. This relates to the child's education, both current and future, the child's religious and cultural upbringing, the child's health, the child's name, and change to the child's living arrangements that make it significantly more difficult for the child to spend time with a parent. There's also a duty to consult the other parent with regards to long-term decisions if parents have joint parental responsibility. Under Section 60 DAC, the order is taken to require each of the parents to consult the other parent in relation to the decision to be made about that issue, and to make a genuine effort to come to a joint decision about that issue. When we look at day-to-day parental responsibility, 65 DAE states that there is no need to consult on issues that are not major long-term issues. This will mean that a person with whom the child is wanting to spend time with not usually need to consult on decisions such as what the child eats, wears, because these are not long-term considerations. All right, why is parental responsibility important? The answer is parental responsibility affects contact. Let's see how that works. Under 61DA, presumption of equal shared parental responsibility when making parenting orders, when making a parenting order in relation to a child, the court must apply a presumption that is the best interest of the child for the child's parents to have equal shared parental responsibility for that child. Again, we see where best interests factor. Under 61DA, 2, the presumption does not apply if there are reasonable grounds to believe that a parent or their child or a person who lives with that parent or child is engaged in abuse of the child or another child at the time was a member of that parent's family, or, importantly, family violence. Now, this presumption can be rebutted by evidence to satisfy the court that it will be not in the best interest for the child's parents to have equal shared responsibility of a child. All right, let's have a look at some typical equal shared parental responsibility parenting orders. It might say, usually at the beginning of parenting orders, subject to any other order, all specify the wife's name and the father's name, have equal shared parental responsibility for the children, and they detail the names of the children. Sometimes you might have each party has sole responsibility for the day-to-day and welfare of the child whilst in their care, even though we see that that is not necessary, that is just within the Act, but sometimes it's easier to define that so parents are more aware of exactly what the difference is between long-term and day-to-day parental responsibility. This is a typical sole parental responsibility order where it says the mother or the father shall have sole parental responsibility for the child, and they just detail the children's name. And then it might also allow for each party to have sole parental responsibility for the day-to-day care and welfare of the child whilst in their care. Now, contact. What is it? Equal care and significant and substantial time. Right, it's important to say that parents do not have any intrinsic rights under the Family Law Act. It is the children's right to be cared for by their parents. So there's no right. A parent can't go in before the court and say, I have a right to see my child. That's not how it works. So firstly, let's look at 61DA, where there is a presumption of equal shared parental responsibility when making a parenting order. So it says here at 1, when making a parenting order in relation to the child, the court must apply a presumption that is in the best interest of the child for the child's parents to have equal shared parental responsibility. That's just their starting point. Then they say the presumption does not apply if there are reasonable grounds to believe that a parent of the child or a parent or a person who lives with the parent of that child, which could be someone in the sphere of influence of that parent, has engaged in abuse of the child or another child who at the time was a member of the parent's family, or family violence. This is how family violence affects parental responsibility. Also below, the presumption may be rebutted by evidence that satisfies the court that it would not be in the best interest of the child or the child's parents to have equal shared responsibility for the child. This is a little bit of a catch-all when there hasn't been family violence, but the court still believes that it's not in the best interest of the child for a parent to have equal shared parental responsibility. Now, this is important. If the court does not make orders for equal shared parental responsibility, then the court does not have to consider equal time or substantial and significant time under 65 DAA, but can make any order for contact the court sees fit, which includes a no contact order against the parent. Now, if we assume that the parents have been granted equal shared parental responsibility, then the court must look at 65 DAA. And now it looks to whether or not the child will spend equal time or substantial and significant time with each parent. Now, looking at A, they consider whether the child spending equal time or substantial time with each parent would be in the best interests of the child. Again, we see this concept of best interests. Also, when it is reasonably practical. And then they have to decide whether or not it should be equal time or substantial and significant time. So, in conclusion, when making a parenting order, the best interests of the child are paramount. The need to protect the child from physical or psychological harm, from being subjected to or exposed to abuse, neglect, or family violence is a paramount consideration. And best interests, which particularly involves family violence, abuse, neglect, affects parental responsibility, which affects contact. I hope this helps.